Hey, I'm Marc Stevens, author of Government Indicted. Website, of course, is markstevens.net. Glad to be with you this April 26, 2017, live from the fortified compound in Mesa, Arizona. Glad to be with you here. The call-in number, if you want to join me, it's 218-632-9399. 218-632-9399. This is episode 18 of the commercial-free Wednesday edition of the No Stay Project. I'll say right off the bat, we may have new material for Saturday, but we will not be live, of course, every other weekend or so. I am traveling, so hopefully we are able to get more new material than just this show to broadcast on the LRN stream. But we will see what happens. You can also reach me on Skype. It's Frank Rizzo3, Frank Rizzo with the number 3. Instant message me first instead of just calling right away. So I'm not getting too many at one time. Let's see. We're gonna have Jermaine call in. We'll get him connected soon for an update. What I wanted to do before we get him on there. There are some very persistent critics on some of the YouTube videos, because most of them you can still leave comments on. There's one in particular within minutes of me responding to something, because usually it's just for the hell of it, just for giggles. Within minutes we'll respond, and this I'll get. This is to my video debunking territorial jurisdiction. And I'm called delusional, and anybody who supports me is delusional, and, I guess we're cross-dressers or something, though I've not seen any evidence of that. At least for me, I'm not a cross-dresser. What a weird put-down, too. Anyway, someone is engaging them, and I have to disable the notifications from all these ridiculous comments that are made. Just email gets flooded because this one just never stops posting comments, and it's incredible how people, when they don't have a leg to stand on, they just strike me as a paid troll. And when I post this, I'll post it in the video here. You'll probably be able to see it here or there, so that you can see who it is. I'm going to leave the username up. It's all public knowledge. And what they continue to do, even though this individual is asking for evidence that the laws apply, and my whole thing is, there's no evidence that these laws apply. For some reason, I guess that's because who's ever paying this who's ever paying them, and Emmer Willard, who's ever paying you, it must be directing you to do this, or you're just really bad at trolling people on YouTube. This is just... At least address the issues that are being raised if you're going to be a critic. But then again, when you're just being paid, it's no big deal. Evidence is never needed to support the existence of a law. Evidence is only needed to support the existence of an occurrence. Constitutional law and the laws of the legislature and case law are self-evident that they exist. The written instruments can be produced and readily looked up by anybody. That's not the issue. This is so stupid. This is one of the stupidest comments. This is the best that you guys can do? We don't have to prove the laws exist. No one's asking you to do that. We know they do. We know it's a written instrument. At least you agree. That's the truthful statement here, is that they are written instruments. Yeah, they're written instruments. They just wrote things down on a piece of paper. What the hell makes you think it applies to me? That's the point. That's my position. My position is you don't have any evidence to. Because just saying it applies to everybody doesn't mean that it does. So, despite someone quoting Christopher Hitchens just above there, that which can be asserted without evidence can be dismissed with evidence. Now, we understand clearly that the people who are forcing these rules on us don't give a damn. We know that. I've never once said, just explain to them the logic behind it and they'll drop their assault. No. We are exposing them as criminals. And for you to continue to say that we're denying the existence of a written instrument, I even say from 1787 or 1910 in Arizona, is just ridiculous. Where is the proof that it applies to anybody? And excluding magic, just saying it applies, what is it, vox et praetera nihil. It's voice and nothing more. Your willingness to put us in prison, your willingness to kill, your willingness to sit and get paid to respond nonstop to YouTube comments, it's not evidence. The fact that you're willing to make money off of this doesn't make it any more legitimate. It's one of the dumbest comments I get. Mark, they exist. Who the hell are you responding to, though? We know they exist. And just because people go to prison because of that is not evidence these written instruments apply in the first place. It's no different than me punching you in the face because after I say, you owe me $1,000 and you don't pay me. I can punch you until you pay me. Okay? That doesn't mean that the written instrument, what I say, apply, it does. If I write it down, J. Whom owes me $1,000, and they don't pay me, and I track them down, or have somebody else track them down for me, and they beat the living crap out of them up until the time that they do pay. That doesn't mean that the written instrument applies. Oh, but Mark, they're duly elected. What the hell does that... What are you trying to convey to me that they were duly elected? Everyone is forced to pay them. Everyone is forced to pay them. They are a criminal organization because of that. So just because someone is duly elected or the people are given a choice in the figurehead doesn't make the written instrument apply anymore. Why? Because forcing people to pay you makes you a crook. And when we go into court, it's not necessarily to convince them of that. How do you convince someone they're a criminal? They're not going to admit it how many times now? Oh, you're right. No, but what we're doing, and have been successful in doing on 3 continents, go to markstevens.net and see the proof. We have documentary proof of this going back years. And that's a fraction of what's happened because we don't always get the documents. Because we're going into court and we're making it and we're bringing out the contradictions. Regardless of how much you insist the laws do exist and they magically apply to everybody. Even when the judge says he's going to ignore that and he's not going to presume you innocent, he's going to take the prosecution's mere claim, as the absolute self-evident magical truth. You still put that damn cop or tax agent, whoever's making the accusation against you, you still have supposedly the substantive due process right to a cross-examination. And we're not asking the police officer or the tax agent, we're not asking them, do you have proof that this law exists? That's what that... We're not doing that. We're simply using principles of logic. We're taking his accusation. He actually said and wrote, you violated the law. Under the rules, they have to have personal first-hand knowledge of that. See, and that's the thing about logic. You cannot prove that I violated the law if you cannot first prove it applies to me in the first place. And turning around and saying the cop doesn't have to prove that, really? You can accuse somebody of violating any rule. How many times have we gone over this? Prove the written instrument. They at least got that much right. Prove the written instrument applies. There are basic principles that are commonly accepted as to why a written instrument would apply to somebody and create an obligation to do or not to do something. And forcing people to give you money is not on that list. Go ahead. Try to do the same thing. Try to operate in the same manner as this fictional entity called the government. Go ahead. Try to bring someone into court and say, I know we didn't sign. I know we didn't agree to this. But it's written down over here. And I am willing to use whatever force is necessary. So that must mean it applies to you. Give me a break. We don't care if YouTube commenters, cops, or even judges, I don't care necessarily if they accept the logic and the evidence against them. We want to be left the hell alone, but they don't have to accept the logic. We're not trying to convince the cops because we know the cops can't be convinced. They don't care. As long as they're getting paid to force these rules upon you, they don't give a damn whether there's evidence that they apply or not. As long as the judges are getting their fat pensions, they don't care that they're supposed to presume you innocent. They don't care that the witness has to have personal first-hand knowledge. They don't give a damn that Brady says that exculpatory evidence and information must be provided to you before trial, even after trial, because they don't give a damn. Does the cop or tax agent have personal first-hand knowledge that a written instrument from 1910 or 1787 applies to you just because you're physically here in North America? And so it's nothing but, I've said it 1,000 times, it's a fallacious double standard. The same rules that apply here don't apply there. Aba fungul. That's what you get for that. That's your response if somebody wants to be illogical with you. Okay? So, you can check out this video. There's hundreds and hundreds. In fact, this particular thread there's almost 200 comments, and over half of them are from these critics. And I would suggest to people, we've got a couple of critics there. They're just YouTube trolls. They're never going to accept the logic. They are never going to accept the evidence. They are going to continue to misrepresent Stop responding to them. Just don't do it. That's why I disable the comments, because they're trolls. We don't need evidence, but you need evidence to disprove it. Give me a break. That's why you just say fungal and you move on to someone who's going to be rational. You can't waste your time with people like that. So let's get to the phones. I know we will get to Jermaine. Yeah, we got Andy in Michigan. Andy, welcome back to the show.
Hey, Mark, this is Andrew again from Saturday, I believe. I told you about the accident and stuff like that.
Yeah, and you got an update for us.
Yeah, so I went into court on Tuesday, and the judge, when I first walked into court, I filed a motion to dismiss. That way it was already on the file, and they had already emptied the courtroom. The judge wasn't even in there. They didn't want to let me see the judge. They told me that court's over. He's not here anymore. Everything's done for the day. And I said, well, here, you already stamped my motion to dismiss. It shows that I'm here. And, I have a court date. I have a motion hearing today. I have to see the judge. And they ended up sitting me on the bench. I waited 20 minutes, went in and saw him. So I go in there and he pulls out the motion to dismiss. He's like, what, you're motioning to dismiss? I said, well, Your Honor, that's for later. Right now we're here on a motion to withdraw my plea. So he's like, all right, go on. I said, since, I was coerced and intimidated and threatened by the prosecutor into the plea agreement, I'm trying to withdraw my plea based on, certain rules and procedures that are, listed in the MCR, which is the Michigan Court Rules. And he would say, well, are you guilty or not guilty? I said, I can't answer that question, Your Honor, as, I'm still, as I was intimidated and threatened into the plea agreement. And he says, well, are you guilty or not guilty? I said, again, Your Honor, I can't answer that question as, I was forced into the plea agreement. Motion dismissed. Well, why? What's going on? that's when the court administrator had said, it doesn't matter, we're done here. I said, well, I'm trying to figure out what's going on. I'm trying to get, clarification as to why I'm being, or whatever. And he says, it doesn't matter. We're done here. And he pointed to the door and said, go ahead. And they pretty much just cut me off. So that's all on the record. That, I asked for clarification. The judge denied clarification and told me to leave. So my next approach would be to file a motion for reconsideration. And also I have to file an appeal with the circuit court.
Yep, that's what I was going to say.
I am currently on day 15 now of the 21-day window in Michigan for appeals, so I have to get on that. The motion of reconsideration, I still have 14 days to file that. And when I go in there, I'm going to have to ask him again, well, why am I being denied this motion? For clarification. They're supposed to, at least give you some type of clarification as to the rules and whatnot for why they're denying the motion. So that's my next approach. And I was also speaking with Tom Mix and a few other guys that are in the chat. And I have a couple of mentors out here in Michigan that are also helping me learn some of these, some different tactics. And so the mentors are telling me that, the rules don't necessarily apply to me depending on if there's an injured party and so forth. And, however, these judges and these people, they swear an oath of office, and we can go down to the county clerk and we can pull their oath as evidence and, bring that up in court and put that on the record. And we have to ask them if they are bound by these oaths and whatnot.
Why bother?
No.
Well, why bother? We already know that we don't have nearly enough time to get into all the issues that I would prefer to get into. You start getting into something like that, and this is why we've pared the script down, and why we go for the throat right away, because we don't have the time, we don't have the luxury or the privilege of getting into a lot of those issues. So that's why I started cutting things down based on so many people telling me. I just, his patience, they have like a 2-minute, limitation on their patience, as any 2 to 5-year-old would have. So that's why we don't get into that. The oath of office is not necessarily at the county clerk anyway. It could be at personnel, or it could be with the Secretary of State. So different places, different jurisdictions have in different places. I typically don't get into that, and I don't recommend doing that. I would rather stick to the issue. If I have to get into an issue of a conflict of interest or something, I can just ask 2 or 3 questions and I can get there. But bringing up the oath of office is just not something I do.
Okay. Well, another tactic was, let me pull up the paper. It was a motion to be advised of rights and informed of nature and cause. And, the introduction is now comes, myself as the people of Michigan by special appearance, not submitting to the jurisdiction of the court with this motion to be advised of rights and informed of nature and cause for the grounds set forth below. Fact, the court stamp on this motion stands as prima facie evidence and verification of my appearance made pursuant to the notice to appear on whatever date, they gave you to come to court. Now, because here in Michigan, I've noticed that they make you sign an advice of rights form. And if you don't sign that form, they're not going to call your case, and then they're going to put a warrant out for your arrest saying you didn't show up. That's another tactic that they try to use to get you to sign a contract with a court and be bound by, their rules and procedures and whatever else. So this motion here is to circumvent that tactic. And the grounds would be, if this is a criminal prosecution, the defendant shall have the rights. And in America, we have the Sixth Amendment rights. I'm not sure of other countries and how they're set up. So in the Sixth Amendment, we have the right to a fair and speedy trial, to be informed of nature and cause, to be confronted with the witnesses against me, to have compulsory process, and so forth. And all of these individual points that are in the Sixth Amendment, I make it an individual point on the motion with a granted box and then a denied box for clarification with a line underneath each point. That way they can either deny or grant my right. And then the conclusion would say, wherefore, for this reason stated above, if this motion is denied, that the court dismiss due to denial of due process rights as protected pursuant to the 4th, 5th, and 6th Amendments of the Bill of Rights. And you know, so, and then, you know, the rest of the stuff for the motion and proof of service and all that stuff. So when you do that, now they can't say that you weren't in court. That's number one. And the other tactic would, let's say the, you know, extortionists, you know, keep pushing forward with the court proceedings and whatnot, you know, because that's what they like to do. We all know that they do that. And the next thing would be to, I guess, use their own rules and laws against them. And you don't, like we all do, we use the Socratic method. So I wouldn't say, well, this law says this and you have to do that. Obviously, we don't do that because that creates confrontation. However, I would say, Your Honor, or Sir, MCR 6.101B states, you know, this right here. What does this mean? Does this mean that there has to be a sworn complaint? Is the complaint sworn? And he's going to say, well, it's signed. I said, okay, is that all that's necessary on the complaint for it to be sworn? And so on and so forth. If they say yes or whatever, now they're violating their own rules. So that's another merit for an appeal. The other thing would be to bring up, for instance, let's say you get a speeding ticket in Michigan. The statute, when you go to the act of the statutes for speeding and traffic laws, speeding or excess speed, none of that is defined in the statute anywhere. So therefore, it's an opinion. It's not even a fact of, you know, their statutes anyway. So there's another law that's about a materially false statement made by a public official or a police officer or a public servant. You would bring that into court with you. Let's say it gets to trial. And you would ask the cop, you know, is this the ticket that you wrote for me? And he's going to say yes. I said, and you said this is speeding? He's going to say yes. All right, so please read the MCL number that's listed on there, or the ordinance number or whatever. And he's going to read it, and then you're going to hand him the materially false statement law. You're going to, will you please read this for the record? He's going to read the materially false statement, you know, whatever. And then I'm going to ask him, all right, so here's the definitions in the statute. Do you see speeding in there anywhere under this statute? Is it defined? He might say, well, either yes or no. And well,
hold on. Maybe it says, like most places, reasonable and prudent, or it may say a certain number of miles an hour over the speed limit. That, to me, seems like a pretty poor way to do a cross-examination. I would rather stick to, did you determine that the laws apply to me because I was physically in Michigan? You did. Now, before I ask you another question, I need you to read this about a materially false statement. And now, sir, knowing that a materially false statement is a felony, I need to ask you, since you testified just now that you determined and you stated under oath that I violated the laws and that the laws apply to me, do you have any proof that that's true? But you still have to prove he did it knowingly. He has to knowingly make a false statement. Just because he's completely mistaken and doesn't understand what the hell he's talking about, because all he's doing is telling him what someone who's higher on the political pecking order him told him, doesn't mean that he knowingly made a false statement. So false statements, they have to know it's false when they're making it. So you can be honestly mistaken. And here, I think the police officer is honestly mistaken when he did it on the stop. He's not honestly mistaken after he gets off the witness stand now. So I wouldn't see that as a way of doing a cross-examination on that particular issue. But on some other issues, yeah, it may be worth bringing something like that up.
Okay. And the other tactics that I had seen were, you know, like the guys that are mentoring me, they have shown me physical proof that this stuff works, that they go about doing things. Hey, be quiet, little dog. You're all right. Hey.
Yeah, if you're gonna have the background, yeah, if you can't get them to stop, I got a line of callers already, so we have to make it quick anyway.
She's done.
Okay.
Somebody was walking in the door. Sorry about that. The other tactic would be to, when you get these appeals and you get all these things, you go ahead and pull the record, you know, a motion or a demand for your the video and audio of the court proceedings, you know, in the record, the stenographer and whatever else, and you bring up these points, and now you can actually file federal criminal charges against, these statists, these, extortionists.
Good luck with that, my friend. You're better off with a complaint. You're better off with a complaint against their insurance company. A federal you and I cannot file federal charges. We can only report evidence of a crime, and it's up to a prosecutor to then bring it to a grand jury, and the grand jury has to, if you're doing it at the federal level, all crimes, misdemeanor and felony, all of them are by indictment. So good luck. I would look into other avenues than that. What I do want to point out is that if you are going to do an appeal, the issues that you're going to be bringing on appeal should absolutely be the kind where the judge has no discretion. You want to show that the judge was supposed to do A and he didn't. No discretion. And if you want to also show that the error has to be one that you don't have to show prejudice. You don't have to show that things would have turned out differently if the judge didn't do the error that he committed. So a big one is denial of a voir dire. Huge. Denial of effective cross-examination. That, to me, is one of the top errors the judge can commit. No prejudice needs to be shown. Zero. You just have to show he denied an effective cross-examination. So as long as you can show that the judge denied you effective cross-examination, and you should be able to look. If you had a chance to prevail on appeal and you don't with the denial of effective cross, you had no chance to because if you have a chance, you're going to prevail on that. Otherwise, they're just gonna rubber stamp it like we just had in federal court. Again, I haven't done that video yet. Hopefully, before I go out of town, we can do that. So that's what I would recommend there. Keep the errors so bad that and keep them few. You don't need a lot. Each error should be no discretion, no prejudice, and should dispose of the case completely on its own. So that's my criteria for an appeal. Each issue should be that substantial. Because one of the big things is they get stacks and stacks of 50 to 100 or 200 page briefs every day. Stacks. Give them something short to the point that they're actually going to be able to read. Give yourself a fighting chance that they're going to read it. And if you've got a denial of effective cross-examination and a denial of a defense, which is usually follows denial of an effective cross, you're on pretty good ground. If you can't win with those two errors, you're the victim of a grossly corrupt criminal organization, and you had no chance regardless of what happened. Okay?
Right on. Yeah, and the other tactic was to file a lawsuit against, the individuals, the judge, the prosecutor, the court clerk, and things like that.
Who's telling you you can file a claim in court against a judge? Who gave you that information?
It's a buddy of mine. His name is Tim. He lives about 5 hours north of me, and he's shown me evidence where you can still file suit. You may not win the lawsuit. That's the whole point. We understand that we might not win the lawsuit. We probably won't win the lawsuit. However, for them to defend themselves in court, it costs them thousands of dollars in attorney fees and whatever else.
No, it doesn't.
For them for defense.
No, it's going to cost you thousands. It's going to cost you thousands for filing against a judge when judges have absolute immunity. I know that technically, if they're without jurisdiction, they committed a felony. No, practically, they have absolute immunity. I defy anyone to bring me documentation from a court where they were suing a judge. Well, I hope that somebody would, not defy is the wrong word, but I would like to see evidence that you're talking about where somebody cost a judge personally or even the county thousands of dollars because they filed against a judge and it was ultimately thrown out. Yes, of course, for absolute immunity. It doesn't cost them thousands. What they're going to do is they're going to file the motion to dismiss for absolute immunity. They're going to have 7 inches worth of citations backing this up. The judge is going to grant the motion to dismiss along with their attorney's fees against you. So this sounds like, I got to tell you, the BS alarm is going crazy right now. I have to see evidence where somebody actually cost, I want to see it. I want to see it.
Okay.
Definitely, because I'm not buying that for a second. There's no way that you're costing the county thousands because you're going to get awarded against you for filing a frivolous complaint, and it's frivolous because it's everybody knows the judge has absolute immunity. So yeah, I got to move on. We got a bunch of calls, but hey. Keep that in mind for your appeal. And remember, the appeal notice is just the notice. There's no argument in the notice. The argument you can put for post-conviction relief on the motion for reconsideration, but there is no argument in the notice, okay?
Okay. All right. Sounds good. Good talking.
Yeah, appreciate the call. Keep in touch. Let us know what happened with the reconsideration.
Most definitely. We'll do. You have a good one.
All right, you too. Andy, in Michigan, we're going to move along to a new caller. We've got area code 775. You're live on the No State Project. What's your name? Where you calling from?
Hi there. I believe you know me. I know I don't have to give a last name, but my name is Ryan Bannister, and I'm calling from Tennessee.
Ryan from Tennessee. What do you got for us today?
Well, little interesting of a case. I'm looking at my citation here, which I got in California, and from a Officer Ron Venzen, 14591, and my issue here is that I've called today the county clerk to try to resolve this through a telephonic hearing. Attempting to schedule my arraignment by telephone, and I was told that they do not offer this that service. And looking through the California rules of court, I found that they don't. There is no in criminal cases they do not offer telephonic hearings. You only get the option in a civil case, and they also leave it up to the court's discretion. There's no requirement. I'd imagine that's probably the case across the map.
Even if there was a rule saying, it's like recording, even if there was a rule saying they always ultimately leave it up to the judge's discretion anyway. There's a rule that in the interest of justice, the judge can waive any of the court rules. And that, and I've used that, which is why I was able to speak on someone's behalf and offer argument and make objections in federal court a number of years ago in St. Paul, because having to be a member of a labor union called like a bar association is a rule of court. And in the interest of justice, that was waived. And I can say there was a Judge Franks who did waive it for me.
Right.
So here, yes, the judge, if there was a rule that said there was absolutely no telephonic hearings, the judge could waive that in the interest of justice, and somebody is, 1,500 miles away. What's interesting, though, did you misspeak when you said you called the county clerk, or did you mean the clerk of the court that the ticket is filed in?
As far as I know, it happened in Menlo Park. Is where the officer issued the citation, and I was told to call the San Mateo County Clerk's office.
Well, if it was a San Mateo Superior Court, yeah, because the county clerk does not. The county clerk is not a court. The county clerk.
Okay. Yeah. Okay. Maybe I misread what I. Yeah. Maybe I'm misspeaking there.
I would still put in the demur and the motion for judicial notice and the Brady request. I would still put that in with a motion to have it heard telephonically, if it's not just sustained. If the judge is not inclined to sustain it, I would still do it and put in there it's a matter of discretion. You are in Tennessee, for heaven's sakes.
Right. Well, I mean, I talked to a number of people, and they said that that's not offered. So what would be the what should I do to try to schedule that?
I would file, I would still file. It's still a matter of judicial discretion, the judge's discretion, to allow that. They said the same damn thing in Oregon. I have audio proof of a criminal traffic proceeding in Oregon, which Norman won. That was posted a long time ago. They didn't like it. But Norman was all the way in Southern California, and this was in Oregon. Of course, he was able to use, he's a disabled combat vet from Vietnam, which may have tipped it more in his favor. But still, they don't like to do it, but they have the discretion to do it. I would lay out, hey, I'm not trying to avoid any alleged responsibilities here. I am over 1,000 miles away. I will spend more money driving out there or flying out there than I would on a fine, which is what they hope for.
Right.
I would still do that. And I would, and if they're going to refuse, they're going to refuse. You may have to fight the whole thing on paper.
So I'm you would suggest that I would start with a letter to the, well, they told me to write a letter to the judge, but of course they were the people that I spoke with wanted me to basically put my defense in writing, which would basically assume that I'd already entered a plea, I think.
Yeah.
So well, I guess what you're saying is in that letter, I would write a request to make it a telephonic hearing based on my location.
No, I would never. It's a common thing, and I'm not saying that this is what you're doing. It's for some reason, people just haven't gotten the whole anarchy thing. And I'm not saying this directly to you, but just bear with me for a second.
Sure.
I am absolutely not a sovereign citizen, freeman on the land, common law, strawman type, or constitutionalist for those who are new to the show. I absolutely reject that. I've debunked that crap on the show. I don't encourage people to use that. I don't know why people who are good people, they're coming to me for help, but they seem to lump me in for some reason. Maybe that's how they found me. I don't know. But I want to say again, I do not recommend this. I'm saying this because a lot of people will, in that area, in that arena, that mindset, will encourage people to write letters to judges. No. What you want to do is, and I have templates for this at markstevens.net, you want to file a demur to the complaint with a request for judicial notice, which makes it more difficult for them to just outright deny the demur. And there's also a Brady request or a discovery request that goes with it. These are in pleading format, and instructions will be you file two with the clerk of the court. The clerk of the court the ticket is filed in so that they can provide a copy to the judge if that's how they do it. And you send a copy to the police officer, or if there's a prosecutor involved, you send a copy of the pleadings, the three of them. You'll always send a copy of everything you file to the prosecutor. And that's what you do. You never just, because if you send a letter, it could be the best letter in the world. It could be huge. It could be the best you've ever seen. But that's not, the judge doesn't have to take notice of anything that's not in the proper format. So that's why we always do it by way of demur. Say the same thing in a demur. They have filed a complaint against me. There's not a shred of evidence to support their claim. There's not a valid cause of action here. And the demur should be granted. So.
Okay. So the three items I'm going to put into it's going to be a demur with two added qualities to it. With you said something about a special notice, or
yeah. The guys in the chat are asking for this, and I'm a little get my Sicilian up about this. You guys know better. Ryan is new. You guys, I'm going to explain it anyway. The demur is based on certain principles of fairness that were adapted into the legal principles.
Right.
And there has to be evidence of an actual crime. So a demur is what you use if the complaint does not have all the elements of the crime pled. And here they're accusing you of a code violation, where the crime only exists by virtue of some scumbags saying so. And by scumbag, I mean legislator. And by legislator, I mean some piece of garbage who forces other people to pay them. So there's also...
now I'm prohibitum, correct?
Right. So this is missing because their base claim is you're physically in California, our laws apply, we have jurisdiction. There's no evidence to support that whatsoever. Zero. And so if you can't show that the rules apply to you, you can't prove that they were violated. So the complaint has failed to set forth sufficient evidence to show an actual violation. There's also, that goes with corpus delicti and a valid cause of action. It's supposed to be an adversarial proceeding, so there has to be an actual antagonistic assertion of rights, which there's no evidence to support that, even if they did it. All those points I just talked about are backed up in the request for judicial notice. So the judicial notice in California and some other places, you can get judicial notice of what the law actually requires. So if the law requires a fair and meaningful hearing, because the Supreme Court said so in Goldberg versus Kelly, in the judicial notice, they have to say on the record, they have to agree to that. They have to take judicial notice that that's what the law requires. If the law requires an act and a result, which is called the corpus delicti, then we want them to take notice that that's what the law is. To be a valid complaint, there has to be an act and a result and supporting evidence. I say it makes it easier for them. It makes it more difficult for them to deny the demur, because if you're taking judicial notice that the law requires, to be fair, requires an act and a result, and they say, this is the law, this is what has to be in the complaint, and it's not in the complaint, then it's easy for us, whether you're on the phone or whether you're in excuse me, you just took judicial notice that there has to be an act and a result. What are the act and result that I'm being accused of here? And they're not going to be able to show that in the complaint because all they can show is an act 99% of the time. So that's the purpose of the judicial notice. It's mandatory if you provide the documentation. Like, I don't remember off the top of my head, but I have a full set of, I have citations from the California Supreme Court discussing that a corpus delicti is an act and a result and is required in every criminal prosecution. Well, they've got you probably in one here, malo prohibita, where that isn't true. So that's why we use the judicial notice. I will put this out there. They have denied it in total with no explanation. They've even denied you were in a adversarial proceeding. That's how corrupt these people are. That's how criminal they are. Because, okay, I don't want to get too much into that, but I hope that explains the judicial notice. And we've talked about this on the show before. If someone does disagree with the taking of judicial notice, they have every right to object and be heard on the objection. So if we're saying, hey, judicial notice is an act and result and is required in every criminal prosecution, they can object and say that's not true. And we could just lay out the documentation to prove that it is. Okay? So that's why we do that. And in California, the reason why when people order from me, you get that is because in California, you can, under the evidence code. 99% of the other places I'm familiar with only allow judicial notice of adjudicative facts, not legal principles.
Okay.
Okay.
Well, all right. So I understand that part. So you're saying in the demur, I'm going to have a request for judicial notice, and then I'm going to have a request for discovery, and that's all within the demur.
No, the demur. There's three separate documents. You have the demur, you have the judicial notice, and then you have the discovery/Brady request. So it's both. So there are some places like California where they're really restrictive even on Brady, and they get away with it. So I know that in advance. We still ask for it because if you have a particular situation where you actually have some proof of misdoings by that police officer, then you can present that and the judge can order you access to the police officer's file. For most of our purposes, though, Ryan, I just want to know if the police officer has personal firsthand knowledge of what he's testifying to. Does he have personal knowledge the laws apply to me because I'm physically in California? That's my main objective there in most cases, because usually it doesn't involve police brutality and stuff like that.
Right. So, all right. So, and those would be mailed all in one letter then?
Yeah, I have instructions that they're all mailed. If there's a prosecutor assigned, you have to send it to the prosecutor. Please, for all that's good in the world, please, if you have a prosecutor assigned to the case, do not mail anything to the police officer or have any contact whatsoever, even by mail with the police officer. We only send it to the police officer when there hasn't been a prosecutor assigned, because we don't want them to charge you with tampering with a witness. Because if you give them the opportunity, they will take it. Because they have no evidence to prove that their rules, their sacred magic rules, apply to anybody. Because then they'll start arguing, Ryan, we don't have to prove that. Really? I'm going to go ahead and object there and ask, am I allowed to argue without evidence? Oh, I'm not. Oh, I can be prosecuted for doing that. See, let me say, real quick, Ryan, let me put this out there. If you are making statements that you have no evidence for, that, at the very least, is speculation. And you're doing it in court. At worst, that's perjury. You're knowingly making a false statement. Well, Mark, not every statement that's made without evidence is false. When you know you have no evidence. In a situation here where when you know you don't have it and you continue making the claim, yeah, that's criminal. And I mean criminal in a lay sense. I don't give a damn whether it violates one of your rules. But it would have to, though, Ryan. I mean, think about it. If the prosecutor is making a claim he knows is false against you, it wouldn't that at the very least be a felony called obstruction of justice?
Yeah, you would think so.
Yeah, you would think. All right, I got to get to Jermaine. Did you have any more questions?
Well, basically, just really a question of practical concern. If I'm not really in a position to be spending money carelessly, and if I go through the trouble of mailing this and all, which I think is valuable, I certainly would like to fight these criminals as much as I can, but I think the issue is if I put the time and the effort and spend the money to mail it, and basically what I get back is denial, or that the only option they give me is to actually come in physically to have the demur reviewed, which basically wouldn't be able to happen. Am I really better off to maybe just pay this and fight another day?
You might turn around and bring up all the wrongs that they're doing to you and do a trial by declaration, which we've actually had a few people prevail on, which, shocked me. I thought, I always said, hey, if you want to do that, that's your choice. But in my view, that's as good as a guilty plea. And I have it posted at markstevens.net. You can check it out. We've had people prevail in California on a declaration, trial by declaration. So you could do that. And if that fails, then you could just pay it.
Well, I'm totally unfamiliar with trial by declaration. Would you be able to elaborate on what exactly that is?
All a trial by declaration is you're laying out why you're not guilty. So you could lay out a lot of the issues from the demur, and you can lay out the fact that the judge is completely unfair, won't allow you to do it telephonically when you're over 1,000 miles away. He is accepting, presuming the prosecution's burden, and he's not presuming your innocence, and he's allowing a witness to testify, because you'll have your Brady violation that you can put in there also. Look, I asked for Brady material and didn't get any. So he's knowingly putting a witness on the stand that doesn't have personal firsthand knowledge, and that's not fair. So you could put that in there. So, but keep in mind, think about it. This may ultimately be something that's better. You may decide because of the distance or whatnot. It may be easier just to pay it. Hey, they see if they offer you a deal. I would file the demur first, and then from there make. If I had to, but I would not try to make a deal prior to a demur.
All right. Well, I really appreciate your help, and maybe I'll call in again after I file the demur.
Yeah, let me know. You can get the demur package at markstevens.net, and it comes with all the instructions. So, check it out and keep in touch. Let us know how it goes.
All right. Well, thanks a lot, Mark.
I appreciate it. Brian in Tennessee, I think I can drop the call line there, because what we're going to do, let's see where we are here. Oh, did not want to do that. But let's see if we can bring Jermaine up. I'm gonna mute that right there, so we don't have to hear that. I'll know when Jermaine is on the line. Let's see. Yeah, that trial by declaration is a tricky one, but I think if I don't think I would do it if I was near the court that I was being charged in. If I was far away, if I didn't, couldn't and didn't want to go through the expense of going out there, then I might consider the trial by declaration or a deal, but I would still file the demur and get some leverage on them. File the Brady request. Get something on the prosecution. For some reason, Jermaine's not picking up. I don't know why. Okay. James, did you just say to send a copy to the cop if a prosecutor is assigned? No. If there is a prosecutor assigned, do not have communication with any of the witnesses, period. That is definitely a way to get yourself charged if you've got a real scumbag prosecutor. It's a good way to get yourself charged with tampering with a witness, which if they have the opportunity to do that, I'm pretty sure they will. So I'm going to try Jermaine here again. We'll see. If not, we'll move on in the last few minutes. Hey, we got Jermaine?
Yeah, that's me.
Hey, there he is. Welcome back to the show, my friend.
Yeah, thanks, Mark. How are you doing?
I'm doing well. You got I haven't had to say Fongul too much this show, so hey. And for those who are interested, I am half Sicilian, so I know it may not sound the same as someone who's Italian or Spanish saying it, but that's the way I grew up with it, though. My grandparents were Sicilian immigrants, and so so that's why it sounds that way. But anyway, I'm sorry, we don't have that much time. You have an update. You went to court today.
Yeah, I did. I went to court, federal court, in regards to a bail forfeiture for $3,000. And then I went to provincial court on all those traffic fines and stuff.
And?
Well, what happened was, so firstly I went to the federal court, and we sat in there all morning. Around lunchtime, we thought, okay, we're on lunch break. Let's go check the other court to see what's going on. So we went over there, and I was with my girlfriend. And one of the sheriffs came and decided that they were going to single her out and identify her for no reason. They pulled her out of the courtroom. I went with her, and he asked her for ID. And I said, whoa, wait a minute. Is she suspect of any crime here? What's going on? And he gave me the whole bullshit, something to do with the Judicature Act. They can identify anybody in the courthouse at any time for any reason. And so just to avoid any trouble, I said, okay, well, fine. She's going to leave, but she's not going to give you her identification. I told them straight up, I think that you're targeting me. You don't want my, excuse me, you don't want my witness here with me in court while I question your jurisdiction. He didn't want to talk about that. So anyways, I just to avoid, because this guy was just like so just short, and like I was like, you know, I don't want anything to happen, you know, anything to happen to her. That would just be horrible. So we just left. I came back. I went into the room. And again, I just went straight into it. Same thing, just asking for the evidence of jurisdiction, etc. They didn't have anything, of course. The entire time, the judge was just talking for the prosecutor, and the prosecutor just stood there mute. And I brought that up several times. I said, you know, are you my accuser, or is the burden of proof on these two individuals here, the prosecution? It didn't matter whatsoever. I mean, this judge, he was just blatantly prosecuting from the bench. He was answering all the questions for them. And he denied my motion. You know, I said, have you read my motion? He says, no.
What?
And I said, yeah, he hadn't read my motion whatsoever. So I said, well,
wow.
Here's a copy that I filed, gave it to him. He skimmed through it. And then he just denied it right there.
What's this judge's name?
His name is Judge Gates.
Well, a big fungal out to Judge Gates up there in Calgary. Well, you probably know where I'm going to go with this. You have evidence now from his own statement to have him to file a motion to disqualify.
That was my question for you today. If you recommend doing that?
Hell yes, yeah, absolutely. Yeah. Quote this Gates. Quote me on that. You could say fungal.
I mean, this guy went so far as to say that he was confident that he had jurisdiction over me and everything like that. And It didn't matter about the evidence from the prosecution. I said, whoa, wait a minute. Are you the accuser? And yeah, I have this all recorded. I recorded for about 3 hours today at court.
You see,
it did on my iPhone, so I'll get it edited and I'll post it up. Okay,
we don't want anyone getting in trouble potentially. Yeah, you definitely have grounds to. Well, let me ask you this. Wow. Did you object and use that one question I've said so many times? Objection, is that because you say so or because the prosecution's evidence does?
Exactly. Yes,
nice.
I did say that verbatim. And he said, the prosecutor's not required, in my eyes, to submit that evidence. Okay. I think that was his words.
Oh, but so, all right. I know I'm backseat quarterback or Monday morning quarterbacking, but a follow-up could be, well, excuse me, could you answer the question directly? Is it because you say so or because the prosecution's evidence does? Because it sounds like it's because you say so. Is that true? Oh, wow.
Yeah, I should have asked that question.
He pretty much gave you the answer, though.
He did, but, you know, I'm sorry to say, I was just a little bit emotional at that point. Like, you know, they're targeting me. They won't let me have a witness. I brought that up in court. I said, you know, I just went on my lunch break. They forced my counsel and witness to leave the premises, and I don't feel comfortable to proceed any further in this secret proceeding because what they did is they emptied the courtroom. When I came back, I was the only person there. And just previously, like a few minutes ago, there was the usual lineup of dozens of people. So somehow they managed to empty the courtroom. So when I came back, it was just me, the judge, the bailiff, and a couple of prosecutors. And I said, hey, look, I don't feel comfortable proceeding. You guys removed my counsel and witness from the premises without any reason. She wasn't suspicious or nothing. She just quietly sat beside me in the court proceedings. So I don't know.
Wow.
It was very, very interesting.
I will say that this has been my experience and many, many people like yourself, Jermaine, that have reported into the show. We are typically kept for last. We had somebody that I think last week waited something like 6 hours that these bastards kept him waiting all day. So clearing the court, a very common douche move for these people. Wow. So I'm not surprised there. I look forward to hearing.
I mean, I just checked my notes here. I had the prosecutor actually say, quote, his words were, it doesn't exist, the evidence of jurisdiction.
It doesn't exist.
That was his words.
Holy crap. Jeez, Jermaine.
Yeah, they just, today was just, it was very interesting. I think you would really want to hear this recording. So Yeah, I'll edit it and I'll send you a copy. Well, I'll try to bleep out the names and whatnot.
Yeah, you know, we've had them admit that before. They did that for our friend Bill, the Twin Mountain Country Store up in northern New Hampshire, where Maria Del Terrio admitted to me, on the phone and in person, in front of Bill at a hearing. There is no such evidence. There is no evidence. And if they had to provide such evidence, they couldn't prosecute anybody. Wow, what a moment of clarity, right?
Right.
Yeah, well, that's the thing. So, there's so much to get to here. This is I got it.
Yeah. So what happened? I'll kind of cut it short because I know there's a lot of people calling.
I'm at the end of the show. I'm out of time.
Okay,
You know,
well,
it's not. I don't have a hard ending like a hard break like I do on LRN. I go a little bit over, but not too much. So it doesn't exist. So did they try to justify why they were still prosecuting you? So I mean, asking. So you're telling me the evidence to actually convict me does not exist?
I did not ask that clarification point, but I did ask a few other questions that kind of implied that.
Okay.
I think it was. I asked the judge. I said, are you willing to make a decision on me to pay this very large fine of $3,000 based on, a case that doesn't have any evidence of jurisdiction? And he was confident to say that he had jurisdiction over me, and it didn't matter about the evidence that was submitted about the prosecutor. I'm telling you, this was his words, almost verbatim, and I've got it on record.
Okay, yeah. So what we need to do, the motion to disqualify is certain, because so anybody else in an extraordinary situation like this is look, okay, objection. You're saying the prosecution doesn't have any evidence. Do you have any evidence to support your claim against your opinion against me? Is your opinion arbitrary or not?
Right.
Wow. And this gets to the heart of the matter, people. This is why we say it's a criminal organization. How many times have you guys heard me say, forcing people to pay you means never having to have evidence and logic and a rational basis for your claims? And here is more proof. We're going to actually have audio evidence of these criminals. Definitely get a motion to recuse or disqualify Gates in as soon as possible. And I would bet the farm that we can do this the same in Canada as we do in the U.S., where if they deny the motion to change the judge, you may be able to maintain in the appellate court a petition for writ of mandamus to review the denial. I'm not certain on that. It's kind of some of my inductive reasoning. It's like going based.
That's right. Every time I go to court, I run around to each and every desk and ask the clerks all these questions.
Oh,
so
good.
I'll ask about writ of what did you say? Mandamus?
Yes. And so I'm making this. I'm making that statement based on what's happened in the past and the fact that all the stuff from the U.S. as far as writs come from the same source as the writs in Canada. Doesn't mean I'm right. I have to check it out. So that may be an option that's available. And so if he does fail to recuse himself, we do have some remedy from there. Holy crap! You're the man.
Hey, it doesn't end there. It doesn't end. Let me jump in here, Mark. So then I went downstairs to provincial court, and there was another judge there. This guy refused to identify himself. I did actually get his name. I went to the clerk and got his name. But so I went in there, and this was, they didn't even tell me what the charges were, but they did say it was criminal. And, I said right away, well, if it's criminal, where's the injured party? Oh, man, you should have seen the prosecutor. She was there typing on her computer while I was talking to the judge. She just stopped right there, dead in her tracks. There's no injured party. And I moved to dismiss. I said, well, this case should be dismissed right here if there's no injured party and you're telling me it's a criminal case. But he wouldn't do it. They were still trying to force me to enter a plea. So I talked to him and I said, well, my issue is if I enter a plea, I'm consenting to jurisdiction. And if you've read my motions, you will see that that's not the case. I'm not consenting unless you can show me that there's evidence that it applies. And so what happened is they globalized everything now. And I'm to come back there on May 12th and deal with everything all together in courtroom 507.
Well, okay. A lot of what you're saying is some good stuff, and I understand it's a stressful situation. But throwing in an affirmative statement you can't prove, if you are forced to enter a plea, you're not consenting to jurisdiction.
He said that himself, though. That was the judge's words. He said, if I were to enter a plea of guilty or not guilty, it would be consent to the jurisdiction.
Yeah, I would say objection. You keep using that word consent. I don't think it means what you think it means. So that adds a new twist to this, that the judge said that. But if you refuse to plea, he's just going to enter a plea of not guilty for you. So if that's the ultimate that's going to happen, you may have to say, objection. If you enter the plea over my objection, are you now going to still consider that to be consenting to your jurisdiction? If you do it over my objection, is that consent too, you jackass?
No, that would not be consent. And would that not also be prosecution from the bench?
No, it's not prosecution from the bench, because the prosecution doesn't even, the prosecution never has discretion or authority to enter plea for somebody.
Okay. But the judge does.
Well, the judge has discretion to do it when, I don't know if that's the right word or authority. He has, at least in the U.S., and I'm guessing it's the same there. In the United States, a judge has authority to enter a plea on behalf of somebody who is refusing to plea, or if they can't ascertain a plea from them, which is why we have the unsigned plea of guilty. So that
I used that in the courtroom. That's why it was kind of a kerfuffle, because I said, hey, we could just all end this now. Here's my unsigned plea.
Yeah.
I'll sign it and file it. And so what they did, they just globalized it, and they're gonna drag me back there and go through this all again.
Well,
so that's pretty much all that happened today. I mean,
well, that's a lot. That's some pretty big admissions. Let's get to work on the motion to disqualify. Use his words against him and the prosecutions, because this is prosecutorial misconduct. They're admitting to this. That's a textbook abuse of process, and get that in as soon as possible. May 12th doesn't give you much time. I would, you should be able to, hopefully get it filed by Friday, and maybe get it set for a hearing. Well, no, you don't get that set for a hearing. And what we'll have to do is, you have to put in there that his bias is so prejudiced. He's so prejudiced against you, which seems to be politically motivated, that a fair trial is impossible. Yes, he's made decisions against you, so you have to show that his bias due to non-judicial matters is so great that you can't get a fair trial from the guy, and we can do that. I believe he's saying that the laws apply to you because of his political bias against you. It's his political position that he's using against you, and he's admitting it's nothing from the prosecution. I'd get down on that right away, and hopefully you can get that filed by Friday, because you got 2 weeks. To if he's going to deny it, to get that petition for a mandamus into the higher court to stop this bastard.
Okay.
Wow, that's an awful lot of crap that they did. It doesn't exist. Another prosecution admitting the evidence doesn't exist. Next that they have to do, Jermaine, is to try to make a claim that they are allowed to argue without evidence. And I'll tell you, at least from my experience with Calgary, and I have it up on the website, when you start talking about arguing without evidence, boy, they back off that real fast. But here, they got a judge that's protecting them, so they may just keep their mouth shut. So.
Yeah, they didn't. The prosecution was silent. I brought it up several times. I said, who's really my accuser here? Because these people seem, the prosecution is just silent. And I even brought that up. I said, well, you're certain that it applies, and you don't need evidence. And so what if I were to say that it doesn't apply and I don't have any evidence to show it, because they kept trying to shift the burden onto me, that somehow I have to prove that the jurisdiction doesn't, or the code or nothing like that doesn't apply to me. So how can I do that?
Did you ask him if you were able to do that, if you could argue and make legal claims like the prosecution and not have to have evidence?
I did ask that.
And
he said that you would have to prove that the Constitution and code doesn't apply to you. And I said, well, I'm not making any assertions here today, sir. I'm just wondering, has the prosecution submitted that evidence, yes or no? And he would just continuously say, well, you have to show the evidence on your end.
I posted a video about that. I'm not prepared to answer that question, but you need evidence, boy. Yeah, get the hell out. That's why Funkle is really the only thing that you need. That's all we should have to say to these people. Just Funkle and walk away. But they have guns. They have a prison system, which, unfortunately, you are all too familiar with. Yeah, nice double standard there, Mr. Gates. We'll have to see what we could do about getting Gates's, maybe a photo and some, some where he's in the Calgary court. We'll do what we can to get that posted. Hey, Jermaine, I appreciate the call. Let me know if you have any questions with the motion to disqualify, okay?
Yeah, thanks for having me on the show, Mark.
Hey, no problem. Appreciate the update. My name is Marc Stevens. You're listening to the episode 18 of the No Stay Project, live from the fortified compound in Phoenix, Arizona. It is April 26, 2017, and that, we'll get the audio so you can hear for yourself. I mean, this is where, look, when you're dealing with crooks like this, and they are crooks, why do you, Mark, again, how can you accuse these people of being crooks? The prosecutor admitted, we just had personal firsthand knowledge, and we're going to get audio evidence of this. Jermaine heard this today, wrote it down in his notes. The prosecution admits the evidence doesn't exist. That is arguing without evidence. Putting someone in jail where evidence doesn't exist. The judge admitting to the double standard. The prosecution doesn't need evidence for their claims, but we do, or here Jermaine does. That is a fallacious double standard. You're dealing with a crook. That's how crooks talk. That's how dishonest. That's how crooks talk. That's how dishonest people conduct themselves. They have no evidence. They admit they have no evidence. They say that you need evidence to disprove them. And when it ultimately comes down to it, they have no problem putting you. It's evidence of the double standard. And what it comes down to is they have no proof. So what they have to do is what? When you exhaust their patience, they have a prison system that they can keep you locked down 23 of 24 hours a day. Honest people don't do that. Honest people just provide the damn evidence. Honest people don't make accusations without proof. It doesn't matter what the content of the claim is. When you make a claim against somebody, you need proof. That's how honest, adult, normal people operate. Criminals, on the other hand, say, it doesn't exist, but I'm going to accuse you anyway. How about Fongul? That's what we got to say to these people. Been great hour here on the No Stay Project. Appreciate the calls. We will not be live this coming Saturday, but we should have all new material. But we will be live next Wednesday. It will be the first live show in May, live Wednesday show in May. Actually, the first live show in May. So May 3rd. So tune in for that. That'll be episode 19. Again, my name is Marc Stevens. This is the No Stay Project. Until next time, salud.